Good afternoon, officers. So this session is on important judgments of Honorable Supreme Court of India and Honorable High Court. A very good afternoon to all of you. Yes. We will be dealing with the important judgments of Honorable Supreme Court of India and Honorable High Court in this session. So I have taken out few important judgments. Some of them are the circulated judgments. So the first one, as you can see on the screen, is Jagjit Singh alias Jaggi versus State of Punjab. This is circulated by order dated 22nd of December 2022. Now, this is a very relevant judgment because in daily proceedings, we have seen that we have been passing orders under Section 82 CRPC. We are declaring the accused proclaimed offenders, proclaimed persons. So in this case, as you can see, the directions were that the judicial magistrates have to take this provision of Section 82 CRPC in its true letter and spirit. And thus, it was said that whenever a proclamation is issued, so we have to provide 2 dates. So the one date is generally fixed, the case will be fixed for 15-20 days ki koi hum date denge, wherein the serving constable will be asked to report whether the proclamation has been issued or not, whether the compliance of the court's order has been made or not. And then in the same order, second date will be given regarding the appearance of the accused, which will be 30 days thereof. Thereof means from the date beyond this 15-20 days. So there will be technically 2 dates. So as we can see in the next slide, it means that if an order of proclamation is made on 1st of December, then the first date would be around 20th of December for the return of proclamation and for recording the statement of the concerned serving constable, serving official regarding the completion of the process of proclamation. And in the same order, the second date for appearance of the accused shall be 30 days thereof, that is around 20th of January. Now, why there was a need, why this thing happened? Because in this particular case, you can see it was noted that the Section 82 CRPC compliance was not made, and thus it was felt that there is a need that the accused should be given at least 30 days after the notice has been pasted. So he should be given 30 days thereafter to appear in the court. So in this particular case, these directions came in view of the fact that the order by which the accused was declared as a proclaimed person. So if the proceedings were seen, so in the proceedings, the 30 days time was not given to the accused to appear in the court. Then there is next judgment, which is XYZ versus State of Madhya Pradesh and others. This is Criminal Appeal number 1184 of 2022. Now, this is the judgment by Justice Chandrachud. And in this case, this is dealing with the cases wherein the instances of sexual harassment or sexual assault is there. So in this particular case, when the female filed a complaint before the police officer, so the police report was not filed, FIR was not registered, and then she was compelled to appear before the court, moving an application for registration, giving the directions to the police to investigate the matter and to register the FIR under section 156(3) CRPC. So in this case, the directions were given that we have seen that there have been numerous directions from time to time by the Honorable High Court and Supreme Court regarding the sensitization of the judges in such cases wherein sexual assault, sexual harassment, or rape cases are there in dealing with these matters. So again, we see that it has been noted that we wish to again reiterate the importance of courts dealing with complaints of sexual harassment and sexual assault in a sensitive manner. It is important for all courts to remain cognizant of the fact that the legal process tends to be even more onerous for complainants who are potentially dealing with trauma and societal shame due to unwarranted stigma attached to the victims of sexual harassment and assault. At this juncture, especially in cases where the police fails to address the grievance of such complainants, the courts have an important responsibility. So here it was directed that whenever a complainant is there alleging that the police has not registered a case, in such cases, which is a cognizable case, then it is the duty of the court to be sensitive in this manner, and on the basis of the facts and circumstances, they can order registration of FIR instead of dealing it as a complaints case. The case of Virender versus State of NCT versus Delhi was referred in this, wherein it was said that courts have to remain alive for treating both the victims sensitively while also discharging the onerous task of ensuring that the complete truth is brought on record. So these are such cases wherein police investigation is required. Right. So the complainant cannot bring the evidence on record, and it will be only the police who can investigate into the matter. And thus it is important for giving direction to the police to register FIR under section 156(3) CRPC. Further, it was held some further directions were given. It is a duty and responsibility of trial courts to deal with the aggrieved persons before them in an appropriate manner by allowing proceedings to be conducted in camera, where appropriate, either under section 327 CRPC or when the case otherwise involves the aggrieved person or other witness testifying as to the experience of sexual harassment or violence, then allowing the installation of screen to ensure that the aggrieved woman does not have to see the accused while testifying, or in the alternative, directing the accused to leave the room while the aggrieved woman's testimony is being recorded. Then ensuring that the counsel for the accused conducts the cross-examination of the aggrieved woman in a respectful fashion. So this is again a very bad practice which is generally seen in the courts, is that cross-examination is done in a manner which further harasses the women. So that has to be avoided. The presiding officer has to take care of this fact that further ostracization of the women is not conducted by this practice. Then completing the cross-examination in one sitting as far as possible. So it is again very, very important that the cross-examination of the women is conducted in one sitting. Again, the purpose is to prevent the harassment of the women in the court. Then the next case is Moolchand versus State of Haryana. The date of order is 23rd November 2022. Again, in this case also, like taking note of the fact that every now and then the office note simply conveys that summons is not received back, served or unserved. And then the presiding officer simply passes the order that summons not received back, served or unserved, let fresh be issued, without going into the fact that what is the reason that the summons have not been received back. So in this, it has been mandated that because there is a technological advancement now. So instead of uh, imposing a duty on the serving official to present in the court a hard copy of the summons, he can even take a photograph of the same of both the sides, front and the back side, and to present in the court. So this can be taken through the cell phone because cell phones are being provided now to the process servers of bailiffs. So that screenshot he can place on record of the photograph which he has taken of the front and back of the summon. And this is basically done to obviate the avoidable exercise of passing repeated orders for fresh service. Because it is generally seen that whenever the summons have been issued, so they are not produced back in the court on the date fixed. And then the presiding officer, because there is a rush of work, there are lot many files to look into, so they generally pass this order that fresh summon be issued. So this to avoid this repeated orders, it can be ensured that they place on record the screenshot of the summons. Then we have, this is another important case because this is a question which is always raised in our mind when we are writing the statement of the prosecutrix under section 164 CRPC, that whether a copy of the same has to be supplied to the investigating officer or not, whether the copy of the same has to be supplied to the accused or not. Because in this particular case, in a routine manner, the certified copy of this statement was applied for in the court and it was supplied by the court. So this was taken note of that whether at the stage when the investigation is still pending and the challan has not been filed. So whether at this stage the accused has any right to receive the copy of the statement of the prosecutrix or not. So in this particular case, reference was made to another case of state of Karnataka versus by Nona Vinakare Police versus Shivana alias Tarkari Shivana. This is a 2014 case wherein it was held. There were certain directions which were given to the police stations. The first direction was, I've not stated here, but because I have stated here only the relevant direction, but the other directions were that as in when a matter is reported by a female regarding commission of a rape or any other sexual offense, then the police officer is bound to record the statement and to take her to the nearest the medical examination officer for her medical examination. And after her medical examination, he has to place on record the medical report, which will prima facie tell about the injuries found on the person, which will tell about whether there's a possibility of, because they generally write that the possibility of sexual intercourse cannot be ruled out. So this is the prima facie document which will be placed before the nearest judicial magistrate, and the nearest judicial magistrate has to be preferably a female judicial magistrate. And so the prosecutrix has to be presented before the nearest judicial magistrate along with this medical report within a period of 24 hours. And the judicial magistrate, after recording the statement, he has to provide the copy of the statement to the investigating officer. And the reason is very clear that why it is to be provided to the investigating officer, because they need to investigate into the matter. So they should know what the prosecutrix has stated before the judicial magistrate, before the presiding officer, so that they can have their line of investigation. Because there are cases where the prosecutrix will say a different version before the judicial magistrate. So the investigating officer should know. So it is important for the judicial magistrate to hand over the copy to the judicial magistrate, to the investigating officer, but with a direction that the content should not be made known to any other person, including the accused. So this is very important. These directions are very important, that they should not make known the contents of the 164 statement to any other person, including the accused. So this was made clear in the state of Karnataka by Nona Vinakare versus Shivana alias Tarkari Shivana. And it was said that this is to be provided and this is to be done, this is to remain protected till the time challan is filed, because when the challan will be filed, the copy which is supplied to the IU will definitely be part of the challan, though the original will be sealed, but the copy will be the part of the challan. So then we have to see whether just filing of the challan, because the challan has been filed, so whether the accused has now got the right, now can he apply for the certified copy of the same. So it was again another case was referred, which is A versus State of Uttar Pradesh. This is 2020 10 SCC 505. In this case, it was held that mere filing of challan does not entitle the accused to any right to receive the copy of the statement recorded under 164 CRPC unless there is the cognizance is taken by the court and there is an order to supply the copies under section 207 or 208 as the case may be. So unless that stage is reached, fine. So, and why we see that? Because before that stage, there can be an application for further investigation. So we can say that the cognizance is taken only when the copies were supplied under section 207, 208 CRPC. So that is technically the order of the court when it's the orders, when by the order the copies are supplied. So in that order, copies of challan will be supplied and the copy of challan will include the statement under section 164 CRPC, the copy of which was provided to the IO, obviously not the original one. So this is the important case. Then the another case which I would like to refer is Sukhpal Singh Khera versus State of Punjab. This is another important case, 2022 Live Law, Supreme Court 1099. You must be also aware of this. This is regarding 319 CRPC application, which is again filed before the courts in most of the cases, criminal cases, where the accused, some of the accused have been dropped. So in this particular case, the three questions were majorly raised. The first question was whether the trial court has the power under section 319 of CRPC for summoning additional accused when the trial with respect to the other co-accused has ended and the judgment of conviction rendered on the same date before pronouncing the summoning order. So in this particular case, though the application was moved during the trial, but it was taken up when the order of conviction has already been passed and the court has fixed the case for the argument on sentence. So there was a gap of 2-3 days. Generally, there's a gap of 2-3 days whenever we pronounce the order of conviction and then we fix it for the order on sentence. So the question which was raised here was, can the 319 CRPC application be taken on the date when the order on sentence has to be passed, because the order of conviction has already been passed before taking up this application. So to understand the answer of this question, another important fact which we need to understand is, when does the trial comes to an end? So in this case, it was said that the trial will come to an end if the accused is acquitted, then on the time when the judgment of acquittal is pronounced, order of acquittal is pronounced. So as soon as the order of acquittal is pronounced, the trial comes to an end. And so 319 application, if pending, cannot be taken after that, because the trial has already completed. And one of the important ingredient of 319 CRPC is that the trial should be there. And in case the order of conviction is pronounced, so it can still be taken till the time the order on sentence is passed, because the trial will come to an end only when the order on sentence is passed. So till the order on sentence is passed, this application can still be taken. But if once the order on sentence is passed, has already been passed, then in that particular case, it cannot be taken. And the next question was that whether the trial court has the power under section 319 of CRPC for summoning additional accused when the trial in respect of certain other absconding accused is ongoing or pending, having been bifurcated from the main trial. So there is again this thing which we generally see in our courts, that if there are 4 or 5 or more than 2 accused, then in that case, in some of the accused may be declared as proclaimed persons and later on they will be arrested and brought before the court. So in that case, again the court has the discretion whether to carry on the trial, their trial along with this or not, or to bifurcate it. So in this particular case, there were other offenders also whose case has already been bifurcated from the main trial. So one is the main trial Another is the bifurcated trial. The of the other proclaimed persons which was being carried on separately. So the question was that now whether this trial has to be stopped, जिसमें conviction already हो चुका है and the case has been put on order on sentence, or whether this accused, if the court comes to this conclusion that 319 CRPC application has to be allowed, and this accused has to be summoned as an additional accused. So with whom this his trial is going to be conducted? With these persons who have already been convicted. So the court held that it is completely purely the discretion of the court, that if the court wants that his trial should go on with the trial of those who have been convicted already, so then in that case, what the court will have to do, court will have to hold this trial which has in which the conviction order has already been passed. So this will be put on hold till the time the new accused is summoned, and then the trial will start de novo. So in order to avoid this, the court again has the discretion. They can say that they can bifurcate, saying that since this has come at the final stage, the accused has already been convicted on the basis of evidences that have come up on record, and so it will not be feasible to carry on the trial of the new accused along with these, and so they can bifurcate. And in this situation, once the court comes to the conclusion that the trial should be bifurcated, then the court has the powers to pass the order of sentence and to consign the file accordingly. Then there will be that will be other case which will be going on from the first stage of the framing of charge. Now, another question is that what will be the evidence which will be taken into account while summoning this accused? Yes, anybody who wants to answer this? Anybody who wants to answer that at this stage, when there is 319 CRPC either filed at this stage or either filed at the previous stage, but taken up at this stage. So what will be the guiding factors? Whether the evidence which has been led, that will be taken into account, or the evidence of, like I said, that there were other proclaimed persons also who were later on arrested and there is a separate file which is going on. So which evidence will be taken into account? Yes. You want to say something? Yes. Anybody who wants to say something on this point, that what is the evidence which need to be considered in this particular case? Yes. I can see one name flickering on the screen. Yes. Nobody wants to say anything on this, that what evidence will be taken into account in securing the presence of the additional accused if we are giving a decision on the 319 CRPC application for summoning an additional accused. So what evidence will be taken into account? So we have to keep in mind the general direction which have been laid down in Hardeep Singh and the other cases wherein it was said that what are the evidence that will be taken into account while dealing with this application. So they are the general principles have been laid down. And again, as you can see, the last question was, what are the guidelines that the competent court must follow while exercising power under section 319 CRPC? So they are the same. They're just the same guidelines which were laid down in the Hardeep Singh's case. And in this case, separately, the separate guidelines were regarding the stage when this application can be dealt with in case the conviction order has already been passed. So this is the important point that we have to understand when the trial comes to an end. Now, there was also an argument in this case that when 319, if we see 319 CRPC, so 319 CRPC says that any accused who can be tried together. So since there will be no trial together, because if the court is coming to this conclusion कि यहाँ पे तो bifurcation होगा क्योंकि ये stage आ चुकी है, इसमें तो conviction हो चुका है, and then we have to just pass an order on sentence. So there can technically be no trial together. So this argument was countenanced by saying that this is not the right argument, because trial together does not mean that a trial has always to be together. It simply means that they can be tried together. So if they can be tried together, when they can be tried together, when they have committed a similar offense, or when they have some role to play in the chain of the events which have taken place. So if it had been the first stage, they could have been tried together. They could have been charged together. So we have to just see that the role of the person who is being called, who is being summoned as an additional accused, is also a part of the main transaction, the entire thing which has happened. And if he had been caught at the first stage, then he could have been tried together. So this is only a parameter which is to be seen. It does not mean that there has to be a trial together. So that is the reason why at this stage there can be a bifurcation also. They can say, okay, we are bifurcating the case because otherwise it will be harassment to the accused persons who have already faced the trial, and हम उनको कन्विक्ट कर चुके हैं, और अब कुछ और आ गया तो फिर हम ये कन्विक्शन को हम क्या कहेंगे कि एक्विटल हो गया, because you are not sure कि what the witnesses are going to say against the additional accused. So to avoid this, it will be better if these two will be bifurcated. So once the court comes to this conclusion that the cases have to be bifurcated, then in that case, the judgment can be passed, the order on sentence can be passed against the accused who were present in the court, and then the summoning order will be passed, but that summoning order has to precede the order on sentence. It cannot be after the passing of order on sentence. This is important. So these are the judgments, and I think I've completed on time. Thank you so much.